Welcome to Friday Friends, RI Elder Info's weekly look at the organizations and individuals providing resources for Rhode Island seniors, caregivers, and professionals.
Good morning, everybody. Happy Friday. It's 9 o'clock on Friday, and you are watching me, Deb Burton, the host of Friday Friends and Executive Director of RI Elder Info, where we have been bringing you information and resources that you or someone you know needs to know about. So make sure you hit the like, the share, the bells, the whistles, all those social media cues, because today we are having a fabulous conversation in regards to estate planning for our friends in the LGBTQ community. So really important that we get this information out to everyone possible. And I am very grateful to all of our sponsors for supporting the efforts that we put out here every Friday. So thank you to Point 32 Health Foundation, United Healthcare, as well as McCarthy Law. Here's a message from McCarthy Law.
Here at McCarthy Law, we practice in the areas of estate planning, long-term care planning, elder care law, and residential real estate. Our focus is really on providing peace of mind to our clients.
If you're interested in scheduling a consultation with our office, you can feel free to reach out to us at 401-541-5540. You can also reach out via website at www.mccarthylawri.com. You also should check out our social media, both on Facebook, Instagram, and LinkedIn for some helpful tips and tricks.
Good morning, Jennifer. How are you?
Hey, I'm doing well, Deb. How are you doing?
Very good. Very good. So tell us, what are the special preparations and considerations that our friends in the LGBTQIA community should think about?
Yeah, absolutely. Well, thank you for having me. And definitely, this is a topic I'm really excited to talk about, just to make sure that this information is out there for families who have LGBTQ members, or for individuals who are starting to think about planning, who are part of that community, right? So there are some special considerations to keep in mind. When we're thinking about these types of documents, I like to start out by talking about the documents in phases, right? So I always start out by talking about powers of attorney. I think they're some of the most important documents for everyone to have in place because they can impact us during our lifetime. But particularly for individuals who are part of the LGBTQ community, it is so important to have financial and healthcare powers of attorney in place to make sure that you're able to advocate for yourself and decide who your decision makers would be if you became incapacitated. So particularly, if you're married to an individual part of that community, or if you're unmarried, if you're a part of a couple and you would want your significant other to be the one to make those types of difficult, healthcare or financial decisions, right? If you want your romantic partner to be the one making that decision, then you want to make sure that they're listed as that primary agent for you, or else they might run into some really significant hurdles when it comes to having access to information, with your physician, or to be able to even be present in the room with you, right? If they are not listed as your primary agent, if they are not considered immediate family based on circumstances, we don't want them to run into any barriers. So I always start out by saying the healthcare power of attorney, as well as a HIPAA authorization, can be really critical for couples to make sure that they have that in place, to be in the room, to have a say, and for you as the individual setting up those documents, to make sure that you're putting in place the individuals that you would want to make those types of decisions for you.
So I have a question about the healthcare power of attorney.
Yeah, absolutely.
I think, a lot of times people assume that, their spouse will automatically be able to make decisions in a crisis if they're not able to, if we're not able to speak for ourselves.
Yeah.
But many individuals who have a same-sex partner were not afforded the opportunity to be married.
Right.
For a very long time.
Mm-hmm.
And thank goodness now that is an option. But
Yeah.
individuals may not have chosen to get married in the interim because they've been in the same relationship forever.
Right.
And so from a healthcare decision-making standpoint, what are the benefits of the healthcare power of attorney? Like what does it allow your designee to make decisions about?
Yeah, absolutely. So exactly, what you stated, Deb, right? For some individuals who might decide, you know what, we've been together forever. For us, marriage is, just off the table. It's not something that we want to pursue maybe at this time or in the future. But having them listed as your healthcare agent can be really significant, right? They're going to be able to make decisions as it relates to things like life support or ventilation, your preferences for organ donation. They're going to have the ability to sit in the room when it comes to doctor's appointments if you need them to be present for it. If you don't have the capacity to make those healthcare decisions for yourself, they're going to be able to speak directly with your healthcare providers or any specialists that you need to work with to make sure that you're receiving that quality of care that you need. So those are some of the decisions that they have the ability to make on your behalf. And it's certainly not limited to just those circumstances, but those are some of the really important things to consider just for those documents, right? And then when we talk about financial power of attorney, even more significant and critical to have that individual named if, particularly if you're in a relationship with that individual and you're not married, right? You want to make sure that your partner has access to the resources that they might need to care for your family. Maybe you have children together, or even if you don't, just to make sure that your partner is still provided for and that they're able to take care of your care needs. So with financial power of attorney, let's say you have individual banking accounts. Maybe you have, a joint account for bills and you each have your own separate checking and savings. Super common to do that, right? And in any couple arrangement. So it's really critical to make sure that that individual is listed as your power of attorney to say that if you become incapacitated, they have no access to those funds. And that is, a really pressing challenge that a lot of LGBTQ couples can face if they don't do that advanced planning to say, I want to make sure that this is the individual I would want to be able to make these financial decisions for me, right? So they're able to step in. And financial power of attorney, I think we think of those immediate kind of writing checks, paying bills, handling those day-to-day affairs, and that's correct. But that also expands to things like your personal maintenance, making sure you have transportation if you need it for certain appointments or obligations you have. Can even include things like long-term care planning to make sure that your partner is able to organize and be able to sign off on any kind of care coordination for your benefit. Those are all critical pieces in place. Even the ability to manage or sell real estate on your behalf. Maybe, you're in a couple or in a situation where only one of you is listed as the homeowner. Now your partner has, no ability to manage that major resource of your estate, right? So that is a huge issue to go through. And without the financial powers of attorney in place, you have to go through, potentially a guardianship process through the court. Maybe there's somebody in your family or somebody in your life who you're related to that maybe you don't feel comfortable with them acting as your guardian, right? But you don't have the capacity now to advocate that for yourself. Now, your loved one, if you're a part of, an LGBTQ couple, they might have to really fight and advocate to be listed as that guardian. We don't know what kind of discrepancies they could face in that scenario. So we're avoiding a lot of that, potential frustration and hurdles that they might have to face by streamlining that process for them and advocating for yourself. I think that's the biggest piece of it, to say you get to decide who makes those decisions for you. Nobody else should have to if you have the capacity now to do that. So those are kind of the powers of attorney, the aspects that I really want to stress when it comes to putting those documents in place. Your romantic partner might not have the immediate access to make those decisions for you unless you have those critical documents in place. But I also want to talk about the major estate plan, right? So, after you pass, right, what happens to your legacy? What happens to your assets? And who gets to manage and control your estate, right? That's really significant when it comes to the LGBTQ community in particular, right? If you are not listing your partner, if you're, if you're not their spouse, then they don't have immediate right or access to your assets. It doesn't automatically go to them. So really looking at your estate to make sure that your estate plan is in alignment with your wishes. Otherwise, in Rhode Island, the default is that it's based on the laws of intestacy. So if you don't designate the heirs to your estate, the beneficiaries of that estate, it's going to go to your heirs at law. If you have a strained relationship with a family member, your estate plan becomes even more critical to make sure that that's clear, that certain individuals you don't want to inherit from your estate, or maybe there's a loved one in your life that you want to make sure is managing and receiving those funds over time, right? So those are a couple of critical pieces. When it comes to your will, that's a really important place as well to nominate guardianship nomination. So if you're part of an LGBTQ family and you have children of your own, and you want to make sure that their guardians are of the same values that you have, and that your children are going to be safe and protected. Maybe you have a child that's a part of the LGBTQ community. You want to make sure that their guardianship nomination is someone that you are going to feel safe with your children being raised by, God forbid, if something happens to you. So that is definitely another critical piece to consider when we're talking about your will and your estate plan. Yeah.
And you've given me so many things to think about here. Mm-hmm. Holy cow. Now, we know that many individuals, many of our friends in the LGBTQ community have estranged relationships with their family members, or are just not affiliated in any way, shape, or form with their family members. But if there were a medical crisis, if there were some, catastrophic event, would the healthcare power of attorney and financial power of attorney that has been executed, would that hold up against the family, who might swoop in and say, "Oh no, I'm their blood family," and try to, maybe push that person's partner out? Would those documents prohibit that from happening and make sure that your partner is able to be the one that, because you designated them? Would that work?
Absolutely. So that's a really critical protection to have in place. If you put those powers of attorney, you're going to have those legal binding documents that show who your authorized contacts are, to make sure that only the individuals you've listed are going to have access to that healthcare information, the ability to speak with physicians and make decisions on your behalf, as well as the healthcare and financial power of attorney pieces, right? So only the individuals that you designate as your agents are going to have that authority to make those types of decisions on your behalf. So that is, as long as they're properly executed, properly drafted, then you're going to make sure that you have that security to say your partner is the only individual, or whoever you list, right, in your life. Maybe it's close family, friends, somebody that you feel comfortable with, to make those decisions. They're going to have that authority to do so. Without those documents in place, then certainly you can imagine scenarios where a estranged family or other individuals may try to create those barriers for your loved ones. So definitely having those binding documents is absolutely critical. And another piece to that, just kind of something that you mentioned that, really I think is important to think about, right? When we have these maybe not even necessarily estranged, but strained relationships with family, and we're concerned about, the process that our loved ones might go through in the future, you can also consider trust-based planning as a wonderful option for your estate plan when it comes to administering your estate. Huge reason for that I do think, particularly for LGBTQ families or couples to consider, it's a private process, which is a really nice protection to have in place if you have concerns that, just having a will in place, the opportunity for it to be public and in, the courts, open hearings. If you're concerned about family that may try to challenge or contest and make it really difficult for your loved ones, pursuing a trust-based option to protect your assets, it's going to avoid that probate process, and it's going to be managed privately by whoever you decide is your trustee. And you can put a lot of protections in place for loved ones. For instance, I have, had clients before where maybe they own property in their name alone, but they have, they're part of the LGBTQ community. They have a long-term partner who they want to make sure has a right to reside in that property for the rest of their lifetime. Maybe the property, wasn't transferred into their name, but they want to set up a trust. They want to make sure that their partner can live there comfortably for as long as they choose to reside in that home. And then if the property is sold, they can distribute the proceeds from that sale in whatever fashion that they decide. But that's a really helpful tool to designate your estate plan, set up your beneficiaries. Only the individuals that you list as your beneficiaries or as your trustees are the ones that are entitled to that documentation, right? So you preserve that privacy if you have a little bit of hesitancy or concern about it being made public in some regard, right? So another really critical protection that I think is really helpful. And if you have children, you can put stipulations in place for them. This is for any, for all families, right? If you have young children and you want to make sure that their funds are held in trust over their lifetime, right? Maybe you don't want them to receive everything at 18. You can put age increment language in there. You can put added protections for their benefit, or, just kind of talking about all things, right? If you don't have any, family members or a particular romantic partner, but you're a part of the community and you want your distribution to maybe go back to some organizations that, are supportive of LGBTQ youth or other protective organizations, you can also designate them as a beneficiary of your estate, right? I think that's a wonderful thing to do. We have a lot of clients who will do a charitable organization as a beneficiary. So that's something to think about as well, right? There's so much we could talk about on this topic.
Yeah. This is fascinating. So I never really thought about the fact that when a will is probated, the contents of that document are public documents. And so perhaps individuals were not known as being members of the LGBTQ community. And so you put the will out there and now it is public. Of course, the individual will have passed, but it may not have been something that they wanted to make public, and or it may be a situation where the individual, their partner that they're naming, may not want that out in the public record for whatever reasons. They would like to keep that information personal.
Absolutely. Right.
I did not realize trusts were different.
Yeah. Right. So there is that privacy that's kind of built in. But what I would say as well, even for those documents, right, even when we're talking about your will or your trust or your powers of attorney documents, I think another piece to consider when protecting someone's privacy and their autonomy in that regard, you don't have to specify your relationship to that individual if you name them as your agent. So if somebody does have concerns about protecting or preserving the nature of that relationship, maybe they haven't come out to their family, maybe they're not ready to come out to anybody, that's okay as well, right? You can still designate and specify that individual without specifically stating what their relationship is to you. And that still ensures that they're either your beneficiary if you wanted them to receive something, or that they're your healthcare or financial agent. I certainly have many clients and individuals who list somebody who's close to them in their life that isn't a romantic partner, right? We can designate anybody that we want to be our healthcare or our financial power of attorney. So even to preserve that privacy, if that feels more comfortable, or you're concerned about political climate and where things have been and if they will change in the future, you don't have to specify that specific relationship. Not that anyone should feel they need to shy away from that, but if that's a concern they have, absolutely, we can preserve your privacy and make sure that is, not specifically listed within your documents, the nature of that relationship. Absolutely.
That's a good point, because we don't know what the future holds. Now, I know when it comes to preparing, if somebody needs long-term care and they anticipate needing to apply for Medicaid, because everybody knows Medicare does not cover long-term care, right? So if they're preparing, and they have an expectation that they may need to be eligible for Medicaid someplace in the next 5 years, married couples have ways to be able to protect the community dwelling spouse. Are there mechanisms available to protect a same-sex community dwelling partner who may not necessarily be a spouse?
Yeah, that's a good question. So, I mean, certainly there are some proactive planning strategies that I would definitely want to consider when we're talking about that type of planning. One major protection to look at would be looking at an irrevocable trust potentially as an option. So you would be able to transfer that property, protect and preserve it as it relates to that 5-year look back period. So you would want to place that real estate into that irrevocable trust after a 5-year period. The equity in that home is protected, so it can't be available to use for long-term care. And then within that specific type of trust, you can put that right to reside language for a romantic partner or for somebody in your life that you would want to preserve that for. So that's one area where you can definitely protect as it relates to long-term care. Another just kind of general advisement that I would consider would also be looking at how you're titling certain accounts and how you're providing beneficiary designations, right? So the ability to let's say, for a joint account, right, that you own with, a partner, making sure that they're listed if they need access to that account, or if we're anticipating potential long-term care in the future, the ability to do any kind of retitling or asset preservation in that regard. Certainly something that you could utilize. Beneficiary designations on things like retirement accounts to make sure that upon your passing, it's going to go directly to that individual. That's going to be really critical to make sure that it's not subject to probate. If it's subject to probate, then there is the ability to do that Medicaid asset recovery in that regard. So making sure your beneficiary designations are up to date. That's another really helpful way to avoid that process. And certainly more advanced planning strategies are going to be a little bit more specific to their situation, how things are titled and how they want them to be distributed. But absolutely, we would certainly meet with any individuals to kind of talk about those more advanced kind of planning and preservation strategies.
Is there a way so that you can make plans before you pass so that it never has to go through a probate court, so that everything has already been predetermined before you pass and none of your personal private information ever has to go out into the public probate court? Can that be done before you pass away?
Yeah, absolutely. It can be. So, a couple of ways to look at that. Definitely, when we're talking about ways to avoid probate, you want to think about making sure that there are no assets that are in your name alone without a joint living owner or a living beneficiary. So let's say you have your checking and savings accounts. A lot of individuals don't realize that you can list a beneficiary on something like your checking and savings account. A lot of banking institutions might not ask you to do that when you set up an account, or maybe you set it up when you were, 13 and you just started saving and you started working, right? In that scenario, you probably didn't know to do that, or you didn't even consider that as something that was important to you at that time, right? That is a really helpful piece to avoid that public probate process, making sure that you name whoever you would want to receive those funds directly as your beneficiary. Now, what that means, they don't have access to those funds during your lifetime, right? Unless you listed them as a joint owner on that account, in which case they would be able to receive those funds immediately upon your passing. So the difference would be, if you want them to have access to the funds right now, you could list them as a joint owner on the account. If you want them to, you still want to have that separation of funds, you can list them as a beneficiary, and that way they don't have to go through probate for that type of asset. definitely an option to do so that way. And then what I would say is for real estate, we'd want to look to see how the real estate is currently titled, just to make sure there are no issues, but certainly, multiple options to avoid probate for that particular asset, right? If you add them as a joint owner, upon your passing, it would pass to that individual based on the type of tenancy you have in place. Or, the most foolproof option would be transferring it into a trust to avoid that probate process entirely. So absolutely, that proactive planning is critical when it comes to just streamlining that process. And I just think for particularly LGBTQ families or individuals, I think sometimes there's a hesitancy to reach out to law firms. I know certainly we've maybe I had inquiries where somebody asked, is your law firm safe, right? Is this a safe place for me? I think it's really, definitely disheartening to even hear that someone needs to ask, right? Our job is to make sure that your plan works for you and that it protects you and it achieves the goals that you need, right? To preserve and protect your family and to protect, your autonomy as an individual. Everyone's entitled to that. So everyone's entitled to that information. I do think in particular for my LGBTQ couples and families, I really want to stress to them the best way to protect yourself and to protect your loved ones is to do that proactive planning. It can be a really powerful form of advocacy. It can make sure that if you do have those difficult relationships with family members that you don't want them to receive a part of your estate someday, right? You can make sure that you have that language, making sure that they're never entitled to those funds. Or if you have, somebody in your life that's always been a confidant to you and always been a safe place for you, you can make sure that that individual is, a part of that decision making for you or a recipient of your estate. So I just think it's so important. Everyone deserves an estate plan, but everyone deserves a place to go to where they feel safe to communicate those concerns and make sure that they're addressed.
Yeah, everybody is entitled to dignity, respect, and to be spoken to with the pronouns that they prefer.
Absolutely.
And it breaks my heart that it is a situation where people have to call ahead of time to make sure that it's going to be safe for them and their family members to even engage in the conversation. Folks are always safe to come to RI Elder Info, period, full stop. And I think it may be a harder conversation to speak about making your plans when you are a member of the LGBTQIA community because you have that added layer of possibly family challenges or the concern that someone may not be accepting of your identity or of your partner. And I feel like this is such an important conversation because we don't know what the future is holding as far as, the laws, the regulations, etc.
Right.
And there are some limitations the way some programs are set up right now. So having that conversation, I feel like it's even more important. Not that it's not important for everybody, but it just feels like it's more critical than ever to have these conversations ahead of time. So if people are reaching out and they would like to talk more about it, should they ask for you or can they just call McCarthy Law?
Yeah, absolutely. I would say that, if anyone is looking for more information or, to get their affairs in order or just want to have a conversation, just to kind of talk about some of the challenges or concerns that they have as it relates to, potential changing political climates and making sure that they're protected or their loved ones are protected, they can absolutely reach out directly to our firm. They can ask for me. I'm always a safe space. So I'll volunteer myself absolutely to any individuals that want to kind of dig into this together. I promise that getting your affairs in order is not as scary as it sounds. It's actually really empowering to do so. So I would say absolutely they can ask for me and I'd be happy to help them. But anyone at our firm is absolutely wonderful to work with, and we want to make sure that everyone at our firm is treated with empathy, respect, and the absolute dignity and warmth that they deserve when they're doing these things. So absolutely.
And I also love that you are able to make the plans if it is for someone's child.
Yeah.
That's a special consideration because sometimes we have our families and they don't come about between the male-female reproductive system. Sometimes it looks different.
Mm-hmm.
And so I love that protecting our children is also an available option through you guys.
Absolutely. Of course.
Yeah. So often we talk about our older adults, but we got to look out for our littles too.
Absolutely, you do. And we certainly, if you have, children that are transitioning to, college, or, they're transitioning into adulthood and they're a part of that community, and you want to make sure that you can continue to advocate for them as well. We also offer young adult protection plans, which are pretty unique. And I can always speak more about that as well. But that's definitely something that we can offer to give that protection when it comes to healthcare or financial decision making as well.
I definitely want to have you back on to talk about that, because with all the kids heading out to college soon, I feel like a lot of people don't realize, like, they do foolish things that freshman year in college and they're 18. Parents may not necessarily have a say when maybe there's a negative outcome to the freshman antics.
Yeah, absolutely.
Yeah,
I'd say freshmen are kind of adults with training wheels. So.
Yes. Well, I've taken far more time than I expected, but this is such an important topic. So I really do appreciate you staying with me today.
Yeah, of course. Thank you so much for having me. I appreciate it.
Thank you. Everyone, here at RI Elder Info and at McCarthy Law, it is a safe space, regardless of your gender identity, who you love, or who comprises your family. You are in safe space here. If you need help, don't hesitate to reach out at any time. We're here for you. So this is the month of Pride, in the month of June, and we are grateful for our very diverse community of friends, co-workers, and family members. I look forward to seeing you all again next week. In the meantime, be well and be kind.